Government's position clear, where does a prisoner go who has a claim of actual innocence based on newly discovered evidence?
So, as this court has explained in, among other cases, Herrera against Collins, if you have a claim of actual innocence, it's got to be paired with another constitutional claim. Now, Congress has made an exception in Section 2255.
So I think your answer there is nowhere other than a pardon.
Well, you could, if it's paired with a claim of constitutional error.
If it's not paired.
If it's not paired with a claim of constitutional error, I think it's going to have to be addressed through the clemency procedure.
Thank you.
So just to follow up on that point, Mr. Fagan, would the idea be that if an actual innocence claim, a freestanding claim, is not available under 2255, it's because Congress has implicitly precluded it by not giving a route to raise such a challenge under 2255?
Well, I think there are a couple of reasons. First, I don't think Congress has disturbed this court's. This court has never squarely addressed whether there's a freestanding claim of actual innocence, and I think if the court were to, contrary to the skepticism, I think the court. I read in the court's opinion in Herrera against Collins, the court were to decide that such a claim exists. I don't think Congress has precluded it under Section 2255. But if it's not an existing route to post-conviction relief, then I don't think it can be read into Section 2255. That is, Congress wasn't trying to create some new ground for relief. Congress did enact Section 2255H1, which kind of mirrors the actual innocence exception as a reason why someone as a showing that a particular prisoner could make to bring a second or successive claim that would otherwise be precluded. But I don't read Section 2255H1 to authorize that kind of claim as a freestanding claim divorced from constitutional error. I think what it does is, if you can meet the actual innocence bar, it is allowing a second or successive claim that relies on some constitutional ground.
I guess I'm just trying to figure out how to articulate the rule. I mean, you offer one way. If we say that if you're going to challenge the validity of a conviction or sentence, 2255 is your option. You know, that rule I can see making sense. Otherwise, it feels like we would have to decide if we peg it to 2255 very specifically, like if you could bring this, if this is a cognizable claim under 2255 and you can't raise it under the compassionate release statute, it seems to me that we have to decide whether an actual innocence claim in a freestanding way is available under 2255, which I take Justice Kagan to be pressing you on.
That's why I'd go with the other formulation, Justice Barrett. And in answer to both you and Justice Kagan, if this helps, we don't really conceive of those things as being different. Section 2255 is the vehicle for raising claims or challenges to the validity of a conviction or sentence. So I think the phrase Section 2255 claim one might think of as something that has some chance of succeeding if it's brought at the proper time. I think the right way to think about it in this context is just the type of thing that is the proper office of Section 2255. And the space that 2255 fills, the role that it fills within the sentencing scheme, is it's the place you go when you have a challenge to the validity of your conviction or sentence. That place is not 3582C1A1. There's no way that Congress wanted the BOP originally, or as the gatekeeper now, or district courts to be relitigating claims of actual innocence under Section 3582C1A1, let alone just a mere argument about disquiet.
Justice Jackson?
I guess it seems to me that